This is beginning with plaintiffs.
Joseph Zayas, Your Honor, on behalf of plaintiffs, the Holdemans.
Okay, good afternoon.
Good afternoon, Your Honor. Captain Gleason, I'm here on behalf of the Bruckmans.
Okay, good afternoon.
Good afternoon, Lawrence Hanson on behalf of Brian Cisco in the court.
Okay, thank you. And Mr. Richard Reeves and Ms. Doris Reeves, are you present? They are not present? Okay. Oh, they don't have a counterclaim in this, right? Okay, so they don't need to be present for this proceeding. And there are some folks that have zoomed in, and are those your clients?
That should be the
Mr.
Bruckmans from Florida. Thank you, Your Honor.
All right. All right, so reviewing this file, it looked like all the claims and issues had been previously adjudicated, with the exception of a question of damages on the defendant's counterclaims. Is that, am I correct? That that's our procedural posture today?
Correct, Your Honor, specifically the counterclaim regarding trespassing the dock.
Yes. Okay. All right, so Mr. Cleavorn, as the counterclaimant plaintiff, then any opening statement you wish to make?
Your Honor, we hope to not be here all day. We do have a realtor that's prepared to testify with regard to the evaluation at issue with regard to the trespass of the dock. And so we're anticipating just his testimony, and probably Mrs. Bruckmans from Florida. And
Okay.
We're not going to keep you here all day if we can help it.
Okay. Mr. Hanson, I think your clients had also asserted the counterclaim.
Yes,
Okay, any opening statement?
I expect that the testimony of the realtor and Becky, and if necessary, we can have a testimony response to the defendant's position.
Okay, thank you. Mr. Zayas, opening statement.
Yes, Your Honor. We are here today to talk about an alleged trespass. I understand, sir, the trespass has already been adjudicated of under 3 feet. That was temporary and has since been moved. It was there for maybe several months. All parties testified in their depositions that it had no effect on anything they did. Now, I will object to the testimony of the realtor. I asked during interrogatories for any expert testimony that they were going to provide, and was not provided any. And therefore, any opinion that the realtor is going to give is undisclosed and therefore should not be allowed in this court. I would contend that there are simply no damages for this trespass, and any nominal damages the court wishes to impose.
Mr. Cleavorn, your response that to an
Your Honor,
objection to any expert testimony.
Again, we listed Mr. D'Angelo, the realtor, in March, almost a year ago, as a witness. And so plaintiff's counsel chose not to do any kind of discovery, ask us anything specific. And so, again, to not do anything or inquire about that, it seems to me to be at their own peril. And so we have listed him as a witness, and he's been a witness listed for since March of last year.
May I respond to that, Your
Yes.
Honor? I asked specifically in interrogatories for any opinions of any experts that they were going to provide. While the realtor was listed, the answer to the opinions was unknown to the defendants at this point, other than longtime local experience and knowledge. There was no opinion given. Now, they would have a duty to supplement that interrogatory if that realtor came to an opinion and provided to me prior to the day of trial. They haven't done that. So to show up today, when I specifically asked an interrogatory for any expert opinions and say, here's our expert opinion, is not permitted by the court rules and shouldn't be allowed by this court.
Well, I mean, they told you who the witness was, and that the witness would testify about their expertise, you know, as a realtor in the area. I guess, what are you saying that they should have provided? Some written opinion?
Or
If there wasn't.
anything as to what his opinion was. If he's going to testify to what the devaluation is of the property, they needed to provide me something, whether that's a written opinion, whether that's a supplemental interrogatory answer saying this realtor and this realtor's opinion, the property was devalued by this amount because of this, something other than we don't know right now.
Okay, so that you have an opportunity to know what that is, so that you can respond by talking to your own group.
Sure, or at least be prepared for cross-examination, Your Honor.
So, I mean, Mr. Cleaver, that sounds like a fair objection. And I guess by way of opening statement too, I mean, can you maybe give me some clue about how you're going to persuade me that your damages would be more than $1?
Sure. Obviously, nominal damages are
Yeah,
always.
I would award
there.
nominal damages
agree.
for a trespass, but
So, there's no good, hard and fast way to approach this.
Right.
There has been a sale 4 lots away from this particular location this year. So there's valuation by way of front footage. There's been condominium sales, I'll call them boatominium sales, a few years ago. There's the issue of maybe a boat rental because the trespass is not only of 3 feet, but we even had a summary disposition picture that showed that the plaintiffs were occasionally tying their boat up against the dock on the defendant's side to the north. So not just the dock trespass, but also I'll call it the boat trespass. So it's not just a 3 foot of lake bottom that's being taken up, but another 8 or 9 feet worth of boat that's tied up from time to time. And so valuing that is a bit of a challenge. However, a realtor would be able to testify that here's some different ways to approach it, whether it's, again, worth it by way of what a front foot just sold for. That's, again, sales type data or a condominium type sale from a few years ago. There's certainly boat rental issues because I think that when you're, and the plaintiffs testified at their deposition. Julia Holderman testified that their dock from 2022, 23, 24, and 25 was in the same location. I mean, that's deposition testimony, and we could go through that.
Was or was not in the same?
Was in the same spot. So they moved it in 2022. And so, and she testified it was in the exact same location from 2022 on. So there's, in essence, what amounts to 4 seasons worth of over the line. And so it's obviously, crimps lake space. It obviously would, and we've also got the mooring issue. That was count 2 in our counterclaim because plaintiff Halderman took the mooring that had been on this spot claiming it was his.
How does a realtor quantify those? I mean, surely you're entitled to and obtain, I don't know if we granted it or you could receive injunctive relief to remove the trespasses or, but then I don't know, I still am not understanding how a realtor helps when the only damages are somehow some impingement on your client's ability to use their water access in some way, right? I mean,
yes, and again,
you're not saying the property itself is devalued in any way because a dock was crossing over by a few feet for a couple seasons.
It's not a taking, so I'm not, but again, to try to get an idea of what, if you wanted to put your boat on Burt Lake and you wanted to use somebody else's property, what would a boat rental slip cost? Well, what would, a person pay to be able to station their boat on Burt Lake? And so again, there is testimony that I think would be available to hopefully be helpful to the court with regard to these are some of the options of different ways to look at how to value the trespass here.
Well, honestly, I mean, I think striking the witness testimony is a serious remedy. However, I mean, I think Mr. Zayas raises a valid objection here that he's asking during discovery. Well, tell me what this realtor is going to say about, any opinion testimony that they're going to give. And if there was no disclosure about what that is, so now not only am I going to be hearing for the first time, as I'm sitting here wondering, how on earth is a realtor going to establish damages for this dock? Mr. Zayas might be thinking the same thing as I am. And he's learning this new way of thinking about it at the same moment that I am. I don't have to advocate for either side. So it's easy for me to sit here and say, I'll just absorb it and figure it out. But that puts Mr. Zayas in a tough spot. So I'm going to sustain his objection and bar the testimony.
Thank you, Your Honor.
Yes.
One more issue that might be worth reaching before we get started, Your Honor. Mr. Claiborne brought up the mooring issue. While that was count of the counter complaint, that wasn't brought up during the summary disposition motion. The court hasn't made any findings on anything related to the mooring issue. And frankly, plaintiffs didn't bring that up in summary disposition. It was part of the briefing. We didn't respond to it in the briefing. The court hasn't made any findings to those effects. From our view, that claim has been dropped. To the extent they want to continue with those claims, we need to go through all the elements, liability, everything. The only issue the court decided on summary disposition was trespass as to the dock, because that was the only thing briefed by the plaintiffs.
You know, Mr. Cleveland, that comports with my sort of recollection of previous rulings. What's your thoughts about that?
I believe the order stated that the only thing is with regard to the amount I'm looking at, paragraph D, and the only amount of damages on defendant's counterclaim remain. So again, we're prepared to go forward. I think the issue with regard to the mooring is the plaintiff would say, I bought it. The defendants in general would say, we've been there since 1991 and we're the only ones who have ever used the mooring. And that's the sum and substance of count 2 of our counterclaim.
Your Honor, if I may.
Well, hang on, give me a second, sir. I'm looking at the counterclaim. There's a count 1 trespass. The riparian lake bottom trespass at the dock. Count 2 is a theft or removal of personalty about removing an anchor or mooring. I didn't make any ruling on count 2. I mean, I know that. And that you didn't ask for a summary disposition on that, or we didn't address it. And at the last pretrial, I even said, so the only remaining issue is the damages on the counterclaim for the dock. I thought that's all that we're here on today as well.
I understood that it's just the damages on the counterclaim. So something got.
But I mean, I don't remember ever considering anything about the removal of an anchor or mooring in this case. I mean, I don't recall that being a drop of it in all these extensive motions for summary cross motions for summary disposition. Mr. Hanson, you have any thoughts on that issue?
Well, I believe that the order of the court that about damages from the counterclaim doesn't say except for count 2. And plaintiff's counsel hasn't before this hearing brought to court's attention, our attention, that they believe that that issue has been resolved. And generally, abandonment of a claim in a proceeding requires far more than what we have presented here today. So if we don't proceed
I don't think it's abandoned. Yeah.
Okay.
Just because you didn't ask for summary disposition of it.
Right. So, I mean, the options would be, if there's going to be a legitimate factual dispute, then maybe we come back another day and have a trial on whether the plaintiffs, counter defendants, moved this and what was the cost of replacing it. It doesn't seem like a prudent thing to do, but if the plaintiff isn't prepared to address that issue, or the court doesn't want to address it today, then it probably should move to another day.
I mean, I'm here, I'll address whatever you guys all want to address. So I miss Mr. Zayas. I mean, I don't think they've abandoned the claim. It's still there. If I haven't adjudicated the liability of it, we have to resolve that. Are you prepared to go forward on that today?
No, Your Honor, this wasn't part of the claim. I would have prepared my clients to testify regarding that. They have certainly their version of events that happened on that. Their claim is it was always theirs to begin with, and the part that wasn't theirs was left on the property. So no, I don't think that's appropriate to go on today, particularly as for the reason that, you know, that order stated, for the reason stated on the record. So certainly when that order was entered, I think you and I were on the same page that that was discussing only the dock issue. And we came here today to discuss only the dock issue.
What did you think was happening on the other issue, on count 2 of the count?
Well, Your Honor,
I'm just gonna mea culpa and say I lost track of count 2 of the counterclaim, which seems apparent from my previous rulings in my order. But I'm presuming that you didn't lose track of that count.
no, Your Honor, what happened at my recollection of the last hearing is that they brought summary disposition as to only the dock issue. We responded, the court made its ruling. The court then said, what's left to decide? The party said, and I think we're on the same page here, the only thing left to decide is damages as to the dock issue. Everyone said yes. Therefore, based on that, I thought, okay, they must not be pursuing the claim for the mooring or anything else, because they said the only claim left was the dock issue.
Yeah, all right. I don't think it's abandoned. And also, I'm presuming that you, I mean, maybe I'm wrong about this, but I'm presuming that you're going to seek appellate review of my ruling on the access, the road access issues. And if we got to an order that never resolved count 2 of the counterclaim and you file a claim of appeal, it's going to get dismissed because we wouldn't have a final order. So we got to get you folks to a final order so that if anybody wants appellate review, they can get it and you guys can move on with some finality here. All right, well. Here's, I think, what we need to do then. We need to have a bench trial on the damages for the dock and also on count 2 of the counterclaim as to liability or damages, unless you didn't have a jury demand on the counterclaim.
There's no jury demand, it's a bench trial.
All right. And if we're going to have to come back for a bench trial on count 2, then I'm going to continue this bench trial on the damages, and then I will allow the testimony of the realtor because you'll have an opportunity to, you know, respond to that. I mean, you're in an unfair position to go forward today on it, but you're not in an unfair position to respond to it if, you know, you get disclosure of what that is. So.
Are you gonna order I apologize, Your Honor, I didn't mean to interrupt. Or do you also order disclosure of those opinions?
Oh, yeah. I mean, I think.
I'm happy to supplement the discovery. That's fine.
Yeah. So I'll order, here's what I think we'll do. And my goodness, my apologies to all the folks that have assembled here today. And I think to some extent, you know, I bear some responsibility for that, for having sort of lost track of count 2 of this counterclaim. We're gonna have to continue the bench trial. It'll be on damages on count 1 of the counterclaim, and it'll be on count 2 of the counterclaim as to the entire claim. I will order the defendants, the counterclaim plaintiffs, within 14 days of today's date to supplement their discovery to provide the realtor's opinion and the basis for it. And then, I mean, you're not going to want to, or then are we going to be ready to go schedule it? But why don't we schedule it? And then if there's something about that disclosure that you think means you got to tap the brakes on this for further discovery or a witness on your own, you can contact the assignment clerk and we can have a scheduling conference over the phone.
Off the top of my head, Your Honor, I would anticipate a motion to strike simply because this wasn't a permanent trespass. And so while the realtor may be able to give an opinion, and I'm just kind of going off the top of my head here, while the realtor may be able to give an opinion as to any decrease in value while the trespass occurred, the fact that that's been removed and the fact the court's order it can't be replaced in the same spot means that those damages have been abated. So I would anticipate a motion to strike his testimony along those lines. I don't know if you want to do that. I mean, the court could certainly probably do that on the day of trial, before the trial, or before we want to have that hearing before.
I'll leave that up to you if you want to notice it on the day of, or you want to notice it at a different time and you guys can continue to talk. I mean, maybe I'm missing something here, but my impression is that at this stage of the litigation, the tail is wagging the dog and it's costing all of you people way more money than it ought to. I don't know why we can't figure out what a nominal or reasonable amount of damages are for this and figure out this mooring thing so that you all can get up to the Court of Appeals and figure out whether I was right or wrong on the merits. We're spinning our wheels here on the minutia of the case, but you're entitled to do that. Well, so let's see. I could have you come back as soon as Wednesday, February 18th. That gives you about 6 weeks. There's a couple weeks for them to give you the disclosure, or I could give you Wednesday, March 18th in the afternoon. Yeah. Oh, are you the Realtor?
No,
Oh.
but I will be here.
Oh, okay.
So I feel like my trip,
Um,
Judge.
Wednesday, March 18th in the afternoon?
I can Zoom, yeah.
If I can have the court's permission to pull up my phone.
Absolutely.
I was generally discouraged in court, but.
I can do Wednesday, March 18th.
I can do Wednesday, March 18th, Your Honor.
Okay. All right.
If the Bruckmans are still in Florida, can.
Yes,
Keep them
you
there
have no
and test-
objection to that? Okay. And in fact, do either of you have any objections to any party or witness appearing by Zoom? Other than we would want the Realtor maybe here in person?
No, Your Honor, I don't.
Okay,
No, you're right.
all right.
Okay, yes, Wednesday, March
So
18th.
so any party or witness other than the Realtor can appear by Zoom if they wish, without the need of further order or stipulation.
And the other, I guess by way of housekeeping as well, Your Honor, my original counterclaim, when we got the survey in 2024 was for 2024. So at this point, just for notice purposes, I would move to amend the counter complaint to cover the years that they admitted they'd moved the dock. So 22, 23, 24, and 25.
That seems entirely proper.
To amend the complaint on the eve of trial, I would respectfully disagree, Your Honor. I don't think that's proper. I don't agree that that's what the testimony was, although I don't remember off the top of my head, to be honest with you. And if he's gonna do that, I think I would have to see more. I do remember the defendants testifying that was there for 1 or 2 years, but I honestly don't remember Mrs. Holderman testifying that it was more than that. I could be mistaken. I don't recall that.
Position was attached to our summary disposition motion at.
All right, well, I guess absent a lack of objection, I think it's going to require you file a motion for leave to amend the complaint, the counterclaim, right?
I was gonna read the section of her deposition to try.
Right, I mean, but
avoid
even
that.
if you're right, even if I would grant such a motion, Mr. Zayas has an opportunity has a right to have notice and opportunity to be heard on the question. And so I think you got to file a motion for leave
Okay.
to amend the counterclaim
Gotcha.
if it's all that important to you.
Okay.
All right. Do we need to have a written order that you supplement the discovery within 14 days, or are you just going to make this?
I'll just do it.
Okay.
You know,
If you don't get it, contact, we'll have a phone conference. I mean, I don't want to over paper the file here.
do you want to give me, if I have to file a motion for leave to amend, do you want to give me that date now and make sure we're all clear?
I mean, I have a civil motion day on February 9th and on March 9th. So you can notice it up, say at 9 o'clock, either one of those dates. And
Is that something I can do by Zoom?
yeah, anybody
too?
can appear by Zoom for that
Okay.
motion. Okay. All right, so what we're gonna do is Mr. Cleavorn and Hanson are gonna get you that supplementation of discovery
Sure.
within 14 days of today's date.
If it matters, I found the quote from. I can
Well, it
still
only
motion
matters
it,
to the
but-
extent you could persuade Mr. Zayas to consent to the amendment. I mean, I don't know that I can just grant a motion that nobody had noticed that. So they'll get you that discovery supplementation 14 days from today. We'll come back for the bench trial Wednesday, March 18th at 1 p.m. It'll be on damages count 1 on the counterclaim, and it'll be on count 2 of the counterclaim in full.
Sure.
If the counterclaim plaintiffs wish to amend their complaint, they'll have to notice up a motion and you can file a response, or if you disagree with it, we'll go from there. All right, my apologies to all folks for any inconvenience for today's proceeding. But I think we're on the right track to get us to the finish line this spring. All right, thank you all.
Thank you, Your Honor.
Thank you.